You're listening to Civic Media. You can tune into any of our live shows on any radio station across the state with the Civic Media app. Find us in your phone's app store and listen anytime, anywhere.
Welcome to Amicus, a law review with Jim Santel, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
This is Amicus, a law review, our weekly weekend review of all things justice-related, government-related, rule of law affiliated. Thank you so very much for spending some portions of your weekend in conversation with me about these very important issues on the broadcast stations of Civic Media in Wisconsin, and also to our many listeners throughout the United States of America. Appreciate you near and far becoming a part of our discussion about these issues. I'm here in Radio Park in Racine this weekend, as always, joined by my producer, Max, and together we're inviting you to be a part of that conversation. You can call in or you can drop a comment into our chat box. That number is 855-752-4842. The number, once again, 855-752-4842. As always on Amicus, a law review, we have an ambitious, today, increasingly nearly achievable agenda because there is so very much going on. It is a lot to consume. It is a lot to understand. It is a lot to digest. These are the times in America when it is especially important, is it not, to be focused upon what our government is doing, always an important undertaking, especially now. And it is not necessary, it is not compelling that every American appreciate every single aspect of the rule of law news, principally coming out of Washington, D.C., but other parts of our country, including right here in Wisconsin. But it is important to get a sense overall of the significant movements and trends when it comes to things principally that our president is doing, but also our legislature mostly not doing. And yes, indeed, what our Supreme Court is doing, and indeed on our agenda in our second hour in our broadcast this weekend. We're going to be returning, as we often do, to the United States Supreme Court because, believe it or not, in the midst of all of the other major issues stealing the headlines of this past week, the Supreme Court also had a very busy week. 5 different oral arguments on major cases, including things like the Voting Rights Act, the deadlines for filing asylum applications, an issue related to the Federal Communications Commission, and again, the authority of agencies to operate based upon their expertise. We've talked about that a lot back on the docket of the Supreme Court just this past week, involving federal internet subsidies, and in particular, addressing something called the non-delegation doctrine, determining whether or not the Supreme Court, as it has with respect to other issues, should dropkick that long-standing doctrine, its approach to that doctrine, that also there. And then also, yes, indeed, among the 4, an EPA case, a Clean Air Act case, having to do with where we bring these lawsuits. What is the venue? What is the location for those lawsuits? Should it be just in Washington, D.C., or should it be scattered around the nation? Those 4 major cases argued before the Supreme Court just this past week. I'm going to talk about at least 3, if not 4 of them during the course of our broadcast this weekend. And then we're going to tell you about the activity on the Supreme Court docket scheduled for next week. Yes, continuing into the first week in April. 4 more cases having to do with habeas corpus petitions, having to do with the Fifth Amendment and its interaction with a terrorism statute, having to do with Medicaid and qualified providers, no small issue in our nation's focus these days. And arguably most important, a major religion case under the First Amendment. Once again, revisiting the Supreme Court is the standards under which we assess an establishment of religion. We know that in recent years, the Supreme Court has not just moved off of, but basically abandoned completely the notion of significant entanglements between government and religion as being the standard by which various pieces of conduct, activities, events are evaluated. Supreme Court, at the leadership of the Chief Justice, more and more moving toward a prejudice or discrimination standard against religion, which opens up the doors dramatically, as we have seen in many cases in recent years. Another one of those coming up this coming week. This coming week, another major religious case under the Establishment Clause of our Constitution, the Supreme Court revisiting that issue. We'll talk a lot about the Supreme Court in the second hour, but our first hour necessarily once again focused upon the big issues of the day. Virtually all of them, even the things you may not believe are rule of law, justice related, in fact, we're going to begin by talking, yes, about this apparent decision. It may well have been a mistake, but wow, was it a significant error by our government, by our Defense Department, by the Secretary of Defense, by our national security folks in publishing beyond just their discrete group of people, decision makers, what are war plans? And we'll talk about how that played out. This is sometimes now being called Signal Gate. Obviously, once again, stealing that gate portion of the language from what happened way back in 1973, 1974, that toppled another president in connection with Watergate. Now it's become practical and practice for us to attach that appellation, that suffix, if you will, to virtually any scandal. This is being called Signal Gate because Signal is basically the platform that our leadership inside the decision-making process to bomb the Houthi rebels, the Houthi tribes in Yemen, there in the Middle East, using Signal, a generally applicable and accessible platform to communicate those plans among each other, and also presumably in error, transmitting those very plans a couple of hours before they actually were implemented to the editor-in-chief of the Atlantic magazine. He is also very much in the news. We're going to talk about what has happened in the wake of that, a couple of the many, many things we can talk about in connection with that Signal or Houthi bombing the Yemen case. But we're going to chat about two of them. One is the litigation already pending in the district court, and its assignment to a judge whose name we already know. And then we're going to provide you with some additional insight based upon my own work in Iraq many, many years ago, and the access that was properly afforded to me and other people invited to participate in discussions about top secret, highly secretive, yes, classified operations, not military, but other things in that venue. I'm going to tell you a little bit more about the specific mechanisms, again, from many years ago that certainly are even more sophisticated today, that our present leadership just in recent weeks had access to. The mechanisms they should have invoked to ensure that there was no compromise of this military operation. We'll talk more about that, and I'll give you some of the acronyms, some of the practical trappings of how that should be done, again, based upon my own involvement, and I like to think my own following of that many, many years ago in the face of and necessarily needing to manage information when I was in Iraq, Baghdad, other places throughout that that Democratic Republic, an ally of ours in the Middle East. Necessarily, we're also going to talk about many other things coming out of litigation. I'm going to talk about some very recent decisions, just a Friday of this past week, having to do, yes, indeed, once again, with lawyers in America. We know that the president has issued at least 4, if not more, executive orders trying to shut down the lawyers in our nation. Lawyers and law firms, big law firms, as we talked about in our broadcast last week, those law firms pursuing interests, representing the interests of clients in court, and advocating for certain positions, all of that attracting the attention, apparently, of the president and perhaps those around him as well. And the president entering executive orders prohibiting those law firms from access to federal courts, which again basically shuts them down when it comes to advocating on behalf of their clients, also removing from them various national security clearances, also prohibiting their vigorous and effective representation, doing other things to shut down law firms he does not like, people he does not like. We'll tell you why it is some of the specific people, including names like Bob Mueller and Andrew Weissman that you've heard in the past, why those people attracted his attention because of their previous associations with the law firms. Donald Trump, our president, has gone after them. We'll talk about exactly what has happened now. What is the docket like right now with respect to those 4 or 5 law firms. And we'll talk about what federal district courts are doing to push back, again, not only on those law firms, but also many other things. We'll necessarily talk about inside the corners of some capitulation, at least 2 of those law firms, Paul Weiss, Skadden Arps, have conceded and are not fighting back against this president, and in fact giving to him not only what he wants, but also conceding along the way that they need to give to him some pro bono, tens of millions of dollars of legal services for interests that he himself, the president himself, would promote. We'll talk about that mixed bag coming out of the lawyer reaction in America and frankly around the world. Big law firms, what's happening and what happened? What happened just this past Friday when judges once again said, Mr. President, you cannot do that. We've got some successes in the federal courts. Once again, district court judges pushing back on this flurry, this fire hose wash of executive orders coming out of the White House in recent times. And yes, indeed, that leads to our other major initiative, our other major segment that we began just last week on this broadcast, Amicus, a law review. We're calling it Injunction Function. You may recall that we spent a lot of time talking about the mechanisms, the due process mechanisms, the legal mechanisms by with federal district court judges and appeals court judges. We're going to talk about one of those in just a few moments, by which they take on challenges to various actions of the federal government, can sometimes even be actions of private parties. We talked about what a temporary restraining order is, what a preliminary injunction is, what a permanent injunction is, the process by which judges take in evidence to determine whether or not something should be stopped or something should be compelled to continue. All of that, a derivation of language about injunctive relief, enjoining something, issuing an injunctive order to direct conduct. In this case, in most instances, directing that the White House not pursue the initiatives and the efforts it's undertaking in a number of different ways. You may recall last week we talked about everything once again from the Venezuelan immigrants to USAID funding to Social Security Administration access by the Musk team to transgender troops in our military to an attempt to recoup EPA monies given to address climate change. This weekend, we're going to talk about more of those under the Injunction Function title, generally. We're going to talk once again about what's been happening inside that Venezuelan case. What did the Court of Appeals do? We're going to talk about DEI and the Department of Labor. We're going to talk about slowing deportation plans, restoring grants to schools, and yes, dismantling the Voice of America. All of that and more coming up on this edition of Amicus, a law review. Stay with us.
You're listening to Civic Media. Stay up to date on the latest news and information for your local community and Wisconsin by signing up for our free email newsletter. Visit civicmedia.us/email to get started.
My name is Jim Santel, and this is Amicus, a law review on the broadcast stations of Civic Media in Wisconsin and beyond. As always, Max and I inviting you to participate in our discussion of these major important issues that do indeed affect our daily lives. It is a lot. There are a lot of things going on. It is important to understand some of the broad trends. And yes, indeed, to the extent that your own particular interest, your lives, your livelihoods, those of your family and friends, other people in your broader communities affected by these, getting into doing those deep dives to understand what is and is not going on in America. And yes, indeed, beyond our nation's borders. We are mindful as we gather together this weekend of this latest catastrophic event in Myanmar and Thailand, a 7.7 magnitude earthquake rocking Myanmar and Thailand, reporting that as many as 1,000 people may have been killed in that tragedy. The numbers likely to increase beyond that. a high-rise building, among other structures, collapsing, killing people in Bangkok. We are thoughtful about our human friends, our colleagues, our partners on the face of this planet, facing that horrific event right now in Myanmar and Thailand. More reporting on that, obviously, in the broadcast stations of civic media and in other areas. That is the principal focus, frankly, of all of us as we think about the humanity involved in an event like that, and necessarily the humanity that we bring to responding to it, not just in Myanmar, not just in Thailand, but across the planet. It is unclear at this point, again, about the extent of the tragedy. It is colossal by any estimation. I am mindful once again from my time in Iraq about the important work when tragedies like this happened in Baghdad, principally war-related, but not exclusively, the tragedies around our planet, some of them natural, some of them man-made, of the important work that, yes, indeed, the United States Agency for International Development did in responding to colossal, catastrophic events like this, helping people who are not Americans, who are not our citizens, our residents here, but nonetheless deserve our help because we can help them. We do not know exactly what the dimension of any United States assistance will be there to Myanmar and Thailand and the people visited by this horrific tragedy. It is simply an example, in my mind, of the kinds of things that our nation should be involved in, principally because it is the right thing to do. It is right to help people who are in these tragic circumstances, to assist them not only in burying their dead and supporting them in their times of mourning, but helping also to reconstruct. That's what the USAID did in the past. An agency once again shuttered by this administration, all but closed just in the past recent days. Again, there's not a direct connection this weekend between USAID and what has happened there. It is an example of the kinds of things under most circumstances under which USAID and our nation, your nation, our nation would have reached out to other countries and provided assistance. We will see whether or not our nation does that, even inside or outside the auspices of the USAID. But I am thoughtful about the fact that the USAID that normally would do that now basically reduced to, frankly, a handful of people inside the State Department, a shell of its former self. Basically, people who are responsible now for shutting everything down, shutting down the contracts that previously would have helped people in crisis, socioeconomic crisis, natural crisis, all kinds of things, healthcare problems, political crises, ensuring governments remain in place to ensure the legitimacy of the statehood and the services that states provide to their citizens, all of that no longer in place. We are nonetheless, first and foremost, thoughtful about our fellow human beings in Myanmar and Thailand, reporting as of early this weekend that at least 1,000 already dead, many, many others plainly, horrifically injured. They remain in our thoughts. They remain in our focus as not only residents of this country, people who have had a tradition of caring about people beyond our borders. That has always been our tradition. We need desperately to reaffirm that and, yes, return to that to the extent, and we have swayed from that important mission. Let us talk about something else overseas, which again is the bombing a couple of weeks ago of Yemen. Again, the particular international events and circumstances are not much in dispute. Most people recognize that this group of Houthi tribesmen pose a threat, if you will, to the Middle East stability. And so Yemen, also if not a republic necessarily, one of our allies there where they're located, compromising arguably access to the Suez Canal right there on the Red Sea, the Arabian Sea, the Persian Gulf, all those areas that you know well when you look at the map there. And so decision made, obviously, to try to address the threats that the Houthi tribes posed. Also Iranian connection there, and obviously our disaffection from the Iranian government. All of that, a part of the analysis has been going on for many, many years. A decision, plainly, at highest levels to bomb them, to try to disrupt their operations there, which, according to reporting, was successful in terms of meeting its goals. We don't know that with great particularity. Those kinds of things are plainly announced by our military. No reason to believe that that's not true. What we don't know, of course, is the extent to which the disclosure of information before that event happened into, yes, indeed, the public domain by virtue of the disclosure of it through this signal access, this portal, this mechanism that is used apparently by our top officials, Defense Department, State Department, National Security, our highest leadership to discuss plans, to present plans, undeniably war plans. And the appellation of anything other than that is simply not supported by the facts and the evidence now disclosed about this. Disclosed to the editor-in-chief, Atlantic Magazine, initially incredulous, not believing that he has somehow gotten through this signal portal, reports on what is about to happen in Yemen, bombing the Houthi tribes there. Nonetheless, he realizes after it happens that indeed this was real, and eventually does the responsible thing, and that is he does not release any of these information pieces initially, but plainly discloses, as he should, as a journalist, as an American, that he has improperly gotten somehow, some way, presumably a mistake. We would hate to think that someone intentionally did that, arguably compromising then the legitimacy of that operation, maybe compromising the security of our troops on the air and the sea, who might otherwise be responsible for making it effective. We'd like to think that was not done intentionally, but an error of the highest order. Again, when I was in Iraq, did not need to have access to any of General Petraeus's, the coalition forces movements in attempting to address the violence there in Iraq during the time of that war, 2006, 2007, 2008, and beyond. But access to many, many things there in Iraq that were of the highest levels of security, and things that to this day I'm forbidden from disclosing because of the nature of that war activity at that time, because of the nature of the security of our forces, of coalition forces. For what it's worth, to wrap a number of different stories together, those forces included the Danes. That's right, Denmark. They were among our coalition forces, our partners, with many others, as you well know, including Great Britain and France and others there who joined us in that effort way back during the George Bush administration. The Danes were there too. They were our allies, now increasingly disassociated with us when we seem to be doing some rattle sabering with respect to the Danish property called Greenland. When we come back, I'm going to tell you more about what should have happened in this matter involving Signal and the bombing of the Houthis, things based upon my reference points, things that are still out there to ensure the safety and security of information, plainly not done by our leadership, a massive, massive security default. All of that here as Amicus Law Review continues. This is Amicus, a Law Review. My name's Jim Santel, your host this hour and next hour, along with my producer, Max. We're taking your comments, your questions, your inquiries at 855-752-4842. We're going to take some of those callers later in this hour and into our next hour as well, focusing initially on what is arguably the top story, perhaps at least nationally, almost as significant as that horrific event in Myanmar and in Thailand, taking the lives of well in excess of 1,000 people as a result of the earthquake there in our own nation, an earthquake of a significant security nature. The seriousness of this cannot be overstated, although plainly the White House attempting desperately to dampen that down, indicating nothing to see here. The operation itself, which may or may not, but probably was successful, not compromising the lives of any of our military. We don't know that for certain, but likely that is the case, and that's not the point. The point, of course, is, as most military officials, in an apartisan, non-political way, not based upon what the Democrats or Republicans say, look at this in abject disbelief that we had our top leaders working off of Signal, this platform base for communicating, and necessarily including in their communications, their chat back and forth, the editor-in-chief of Atlantic Magazine, who only when the White House said he was not in fact given any war information, any war plans, only then did he release it. And boy, is it clear from what he got that these are indeed battle plans. They may not have been all of them. They may not have been the specificity at the very granular level that we would have seen as our military forces there in Yemen bombed the Houthi tribesmen and the rebels there. Nonetheless, undeniably war plans. No one reasonably looking at this would come to any other conclusion. And so the question is, among many other things, what should happen here? Well, again, one of the things that should happen plainly are investigations. Yes, indeed, it's important to find out exactly what happened. It is disappointing at the highest level that apparently our leadership is not going to be doing that. At the top of that leadership is our Attorney General, Pam Bondi, who has already come to the conclusion that there is nothing to see here. A good and decent and oath-keeping Attorney General would have at least opened the file and said, we need to investigate this. Let's have the FBI look at what happened here to make certain it doesn't happen again and to figure out whether or not there was any compromise in our national security. Indeed, to determine whether there was any criminal violation of our securities laws. We don't know that. It may not appear from the surface that there were any, but we don't know that. And until an investigation is conducted, that's what the U.S. Department of Justice, under all administrations, Republican and Democrat, would do in these circumstances. Not this Attorney General, not this Department of Justice, poo-pooing that and saying it's not going to happen. We plainly have another office, the Office of Inspector General, in the Department of Defense, arguably the Department of State as well. Obviously, we know the president going after those people. Apparently, they're not going to be doing any review. They don't have the authority to bring charges. They don't have the authority to go into court and litigate any of these issues, but they do have investigative authority. Inquiries. We've seen this a lot. Both Democratic and Republican administrations, the IG, the Inspectors General, in virtually every agency, reviewing things that happen, typically errors being made, and making recommendations about what should happen in the future to ensure that those errors do not continue. That's not happening. And then, aside from the calls of some members of Congress, appears that our leadership in the Senate, our leadership in the House, also not at all interested in doing any oversight, which the committees of both of those chambers of the Congress should indeed do. They've done that in the past. We know that. They're not going to be doing that either. And so it turns upon journalists. It turns upon you and me also, perhaps making FOIA requests, Freedom of Information Acts about this, and yes, indeed, some litigation, which we'll get to in just a moment. But what should have happened, aside from, again, all of these investigations apparently not going to be taking place, at least not anytime soon? Well, when I was in Iraq, again, with this kind of information, again, I was not there as a military person at all. I was a civilian working with the rule of law institutions to try to recreate, along with some of my Department of Justice and Department of State, and yes, Department of Defense colleagues, the rule of law, prisons, police, courts, judges, the due process that needs to be established in the wake of the Saddam regime. That's what I was doing there in our rule of law office as the Justice Attaché and the rule of law coordinator on behalf of the ambassador there in Baghdad. What access did I have? Well, I had some mechanisms there that needed to be accessed when indeed there was confidential, security, classified information. One of them is called the SIPRNet account. It was a unit that actually sat adjacent to my desk there on the first floor of the embassy, which was at that time, of course, Saddam's old palace. It's called the SIPRNet account. And all sorts of banners all over it about the importance of accessing it, not producing documents absent those with which you're willing to ensure their safety and security. The Secret Internet Protocol Router Network, that's SIPRNet. And it is a mechanism that probably is even more sophisticated now than it was when I was in Iraq. That's the mechanism for exchanging information, for exchanging documents of this highly secure nature. You can't get into it absent your clarity and your clearance, rather, to get into that mechanism and to ensure that no one else has it, the SIPRNet account. And then more importantly, if you need to sit down, as we did virtually every morning when I was in Iraq with the ambassador and others on his country team, which is what the State Department calls his group of leaders there. Where do we get together? Not always, but often, to discuss highly secretive matters, again, still not going to be disclosed by me or anyone else around the table, and what's called a SCIF. You've heard of these. It's a sensitive, compartmented information facility. Sensitive, compartmented information facility, a SCIF. It is basically We sometimes call them the cone of silence, if you will. Some friends of mine have described it that way. You go into this, you leave your phone outside, you leave your electronics outside, and you know that everything you say inside that small, sealed room cannot be escaped, cannot escape into the public domain, cannot be transmitted, cannot be found out by someone aiming some listening devices at the SCIF. It is sealed as tight as possible. And there are SCIFs both domestically and overseas in our nation's areas of security. We've got them right here in Wisconsin as well. Law enforcement uses them all the time. We use them, again, at the highest levels in Washington, D.C., and it may well be that some of these discussions took place in a SCIF or SCIFs at the Department of Justice, at the State Department, at the Defense Department. The Situation Room in the White House is one big SCIF, and that's the reason why the president and others go there when they're discussing these highly, highly sensitive things. Was that used here? That's the kind of thing that should be investigated by the Attorney General, by the Inspector General, by the members of Congress focusing upon all of that. There's also something called JWICS, the Joint Worldwide Intelligence Communication System. Another one of these mechanisms. It's secure. It is not signal. You can't get access to it. You can't accidentally send somebody some information who doesn't have access to it, doesn't have the clearances that I had, that others have, that people inside government need to have. And again, another mechanism, many others, and basically the mechanisms through which information, classified information, is handled appropriately. Not here, and we're not going to get investigations about it. The government, our administration, moving very quickly onto other things, apparently, even though questions remain about whether or not this mission was compromised. Perhaps it was not. But we should know that, and we should do those remedial kinds of things to ensure that this never happens again. Can we get that guarantee from our president, from our attorney general, from the Secretary of State, from the Secretary of Defense? We should insist upon that. And absent that, apparently the one thing that is happening is some litigation. Yes, that's right. We're going into federal court now. Indeed, on Wednesday morning, a judge named James Boasberg. We're going to talk more about him in just a few moments. You know him well because he's also the chief judge of the district court in the District of Columbia. Judge Boasberg presiding over that Venezuelan immigrant case. 200 Venezuelan immigrants now in a high security, maximum security prison in El Salvador by virtue of the government's rendition of them, their deporting of them to that nation on the basis that they believe that those 200 or some portions of them are threats to the national security of our nation. In any event, Judge Boasberg once again involved in this signal matter. He was assigned just this past Wednesday to preside over a lawsuit. Again, in the wake of no other investigations going forward, you've got private individuals. The lawsuit, the civil lawsuit alleging that Trump cabinet secretaries and all these other people whose names you've seen in the news recently, national security aides, all the people involved in this. Yes, it's a scandal, but more than that, it's a nightmare with respect to our national security. Violated. The allegation is they violated federal record-keeping laws when they used this Signal chat group to discuss this military strike in Yemen against the Houthis. And they inadvertently included, once again, this Atlantic journalist in that group, providing him with all the information that they were discussing at a highest level. Very significant that Judge Boasberg now, there are about 20 judges altogether in the district court, randomly assigned to this case. He's got it again, obviously drawing the criticism not only of the Attorney General, but the President once again. Notwithstanding the random nature of it, yes, indeed, it happens among the judges there. He's got this case as well. And a spokesperson for Judge Boasberg confirmed the case was assigned to him through that typical random assignment process, 20 judges there. The assignment of the case to Judge Boasberg, again, comes a couple of days after the Trump administration in that Venezuelan deportation case invoked the state secrets privilege to prevent him from getting details about that operation that resulted in the deportation of those 200 people, those 200 Venezuelan immigrants to El Salvador and their imprisonment there. I'm going to talk more about that in just a moment or so. And of course, all of this further underscoring not only the involvement of the federal judiciary, they're apparently going to be the only ones who are going to try to get to the bottom of this at all, but also the important role that judges play generally in all of this. We know as well that judges are involved as we migrate now from that major story to many others intertwined. They are all connected, are they not? Because you've got administration doing all kinds of things that plainly are being found unconstitutional, illegal, contrary to what the Congress has said a president can do. All of them intertwined as we try to untangle some of this here on our broadcast. We know as well that federal judges much involved with lawyers and these other executive orders entered by the president, by the White House in recent days to shut down law firms. What's the inventory on that? What do we need to think about when we think about the president's efforts to try to stop law firms from engaging in the practice of law, not just arguably in violation of their commercial rights, their First Amendment rights, but according to judges now, 3 of them, who have looked at these things, these executive orders, and said, Mr. President, you can't do these things. We know previously that Judge Beryl Howell, she is a district court judge. We've talked about her in the past. We know that Judge Beryl Howell, with respect to a law firm named Perkins Coie that has offices around the country, including right here in Wisconsin, that the executive order trying to shut down Perkins Coie from doing its work on behalf of its clients, on behalf of interests that the president doesn't like, that particular order smacked down by Beryl Howell saying, no, Mr. President, you can't do it. She is horrified that a president would think he can do that. It's a clear violation, she says, of the First Amendment. And yes, indeed, 2 more cases just on Friday evening of this week. Judges, again, temporarily blocking the executive orders as to 2 more law firms. One of them, a White House effort to punish a law firm named Jenner & Block. We talked about that last week. And another one named WilmerHale. 2 major big law firms. One judge calling the effort to do that by the president disturbing, and the second calling it a constitutional harm. The case of Jenner & Block. Again, Judge John Bates, Federal District Court, once again, Washington, D.C., issuing a temporary restraining order against the Trump administration, citing, yes, indeed, violations of the First Amendment guarantees under our Constitution, talking about an unconstitutional interference by our president with the right of the clients of the firm to select lawyers of their own choosing. Another judge, his name is Richard Leone, also temporarily blocking a separate executive order with respect to WilmerHale, another law firm, very big law firm, does a lot of government work as well. The judge writing condemningly about what the president did in that case. I'll tell you more about what Judge Leone did as Amicus Law Review continues, and then take an assessment of what all of the law firms are doing to oppose the president and then acquiescing in some areas with what he is asking them to do. All that coming up on our next segments of Amicus Law Review.
You're listening to Civic Media. Find the latest news, information, and archives of all your favorite shows on the Civic Media website, civicmedia.us.
My name is Jim Santel. This is Amicus Law Review. We are beginning our discussion, as we are now doing virtually every broadcast, of these attempts by our president, by the administration, to stop things, to halt the functions of government in many ways, big and small and in between, and also now to attack lawyers and to prevent them from doing the work that they have done. We know already that the law firm of Perkins Coie has gotten an injunctive order from a district court judge in the District of Columbia, preventing the judge from shutting them down when it comes to access to the courts, access to litigation, preventing their clients from choosing them to serve as their representatives. And now, just on Friday of this past week, 2 more judges, Judge Richard Leone and Judge John Bates, with respect to 2 more law firms, WilmerHale and Jenner & Block, also saying, no, Mr. President, you can't do this. Judge Leone writes this. He says, there is no doubt that this retaliatory action, he's talking about the conduct of our president, chills speech and legal advocacy, or that it qualifies as a constitutional harm, where it goes on to write, the injuries to plaintiff here, that is, again, the law firm itself and its clients, here would be severe and would spill over to its clients and the justice system at large. The law firms, again, alleging violations of the First Amendment to free speech, free association, saying that the orders violate the due process clause of the Fifth Amendment by hurting the firm's ability to practice law. Also, the Sixth Amendment for undermining the relationship between attorneys and their clients rights to lawyers of their choosing. Significantly, Wilmer Hale in this case is represented by former Solicitor General inside the Department of Justice. He comes from Green Bay, Wisconsin. That's where he comes from. He is often in the news taking on these kinds of appropriate cases. He's right now been tapped by another federal district court judge to figure out what to do with that case involving Eric Adams. His name is Paul Clement. He is a major figure in the conservative legal movement. He is a good and thoughtful and balanced lawyer, and he is now representing Wilmer Hale against the president, against this White House, saying, Mr. President, you cannot do this. Those are the three cases that are pending right now that are certainly going to be the subject of more litigation going down the road. We also know, however, that the president has entered executive orders with respect to two other law firms, Paul Weiss and Skadden Arps. They're both big law firms positioned principally in New York City. As to both of them, unlike the other cases where the law firms have said, no, Mr. President, you can't do it, and have gotten support from our federal judiciary who say that the president cannot do these things, in these cases, Paul Weiss agrees to back down and to identify what their own wrongs, what in the past that they might have done. They've done no such thing. And also to provide the administration with $40 million in free legal services, pro bono legal services, efforts, initiatives, interests that the president selects. And now Skadden Arps, another major law firm, agreeing to provide $100 million in pro bono services, again, at the bidding of the White House, saying, Mr. President, we will abide by what you're doing. That prompting, obviously, a huge amount of pushback there in New York and other places against those law firms who are acquiescing, who are saying, yes, indeed, you can do this. Corners of capitulation by these law firms. Interesting that the district courts are upholding the rights of these law firms to go forward, again, enjoining the president from doing what he is attempting to do. As we continue with our broadcast, we'll talk more about those injunctive actions, not only with respect to the lawyers, but also Venezuela and DEI and deportation plans and schools and the Voice of America. All of that coming up on Amicus, a law review. Before we get to all of that, in our heading of Injunction Function, we have got a lot of terrific callers on the line. We appreciate that so very much. We've been talking about a lot of different issues already this morning, including that matter involving Signal, the law firms, injunctions, all of that plainly, appropriately inciting and encouraging and bringing to the fore your appropriate, your thoughtful, your good comments and questions. Let's go to those right now. Appleton brings us Cindy. Cindy, thanks so much for being part of our conversation on Amicus, a law review.
Well, good morning, Jim, but I'm just beginning to wonder with what's going on with this administration, if this isn't the coming to fruition of some major coup that's been in the works for the last 40 to 50 years, because I don't know where everybody is. Where are all of our former presidents, our former vice presidents, our former FBI people, our former attorney generals, our former Supreme Court justices, our former heads of states? Where
are they?
Raising hell about
Yes,
them?
right, Cindy, right. They can appear on television that frankly not everybody looks at, and perhaps you and I and many of our listeners do. I think it's a very appropriate comment, right? Let's push back on this and advocacy, yours and others. What kinds of things have you seen them do, if anything, the folks who are pushing back on this, Cindy?
I haven't seen anything.
Okay.
That's why I'm wondering if there's some major coup that's been in the works for all these years. I don't know. I can't explain it.
Right. We do have, to your very good categorization, we've got former justices of the Supreme Court, some of them still active out there. They should be out there, right, commenting upon how inappropriate this effort to, number one, impeach judges because you don't like what they do. Number two, to push back on this notion advanced just this past week, Cindy, I'm sure you've seen this as well, by our speaker who said maybe we should invoke the power of the purse to affect the budget for our judges. Maybe, in fact, we should limit their jurisdiction. Let's go back to our powers there and maybe restructure the federal judiciary. All of that. Where are the justices, right, saying we shouldn't be doing that? Where are, Cindy, to your very good point, where are our former presidents, our vice presidents, our leaders commenting about this, our appointed representatives, our state officials, right? And some of them are doing it. You hear some of them pushing back. We need more of that, right, Cindy? And appreciate very much the advocacy here. Got to get out there and do that, right? And make certain that people understand the seriousness of this, wherever it comes from. It may well have been in the books. It certainly is a part of a playbook that is now reaching fruition. Cindy, appreciate very much your contributions to our discussion this weekend on Amicus. Keep that good work up and speak your voice and be articulate out there as you plainly are. Let's talk also to Dale calling in from Wausau. Dale, glad to have you a part of our program.
Yeah, thank you for taking my call, Jim. Signal gate, as we are calling it, may be a diversion, something for the American public to concentrate on, while at the same time there may be communications that are being done in a skiff or completely secure form between Trump administration and Putin. And this reporter being included in the signal gate may have been done on purpose to get the word out about the use of signal.
Interesting, right? And again, Dale, to your very good point, how to determine whether that happened or not and what's going on right now, we need to have an inspector general investigation, right? We need to have the Department of Justice doing that. All of that needs to happen. Dale, appreciate the comment, the observation. We'll do more of this, taking more callers as Amicus, a law review continues.
Welcome to Amicus, a law review with Jim Santel, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santel.
This is Amicus, a law review. My name is Jim Santel. This is our second hour of our weekend broadcast on all things law-related, justice-related, government-related, rule of law-related that are important to understanding not only what's going on in our nation, our world as well. Appreciate tremendously the comments, the questions coming in from our callers. Appreciate Cindy, appreciate Dale, who in our first hour raised serious questions about what's going on inside our government in the wake not only of the matter involving the Signal chat group and the compromises there of undeniably of the security information about that military initiative in Yemen with respect to the Houthi tribesmen, the Houthi rebels there, raising questions about what we do and do not know. Is this a coup? Is there something else? Is there a larger conspiracy? What's really going on here? Is this all subterfuge for something else, Dale suggests? And the fact that we have got legitimate, reasonable people in America raising those legitimate questions calls for an investigation, and that's the point, right? Our Attorney General has said she is not even opening a file on any of this. We've got inspectors general out there, State Department, Defense Department, who should, under any other normal circumstance, be undertaking an investigation of what happened here. And yes, we need congressional oversight as well. All three of those should happen. Various levels of responses, various access to kinds of information. And yes, you can do virtually all of that without disclosing any of the classified high-level national security secrets. You can do things in court under seal, what's called in camera. You can have classified briefings on Capitol Hill. You can do all kinds of things inside the offices of the inspectors general that do not expose that very secret and important information into the public domain. We're going to get none of that. And so instead, we're going to be getting at least one lawsuit, again, pending now in the district court in front of Judge Boasberg, again, brought with respect to allegations that by virtue of using Signal, these leaders of our government engaged in record-keeping violations of the law. And again, that piece of litigation pursuing now the only remedy apparently available to us as Americans. Appreciate Cindy, appreciate Dale, appreciate the comments of all of you on this very important issue. Appreciate others who are calling in this morning. Mark, as always, thank you for your comment, your question, your inquiry about the subject matter on our syllabus today. Mark, go ahead.
Yeah, a couple of the issues you made. I looked up what a skiff room is, and this is where those discussions should have been taking place.
Right.
Discussing the attack on the response to the Houthis, their assault on shipping. But and they're just ridiculous that Pam Bondi doesn't want to open this up. That indicates to me that there's something hinky there, because when I was auditing, if somebody didn't want to show me the documentation, that's why I dug in my heels and said, no, I need to see that documentation, period. But for the present ordering, shifting gears, for the present order that no, these law firms can't operate in our courts anymore and all this, I mean, that's clear and simply nothing. That's something beyond his official duties to be doing something like that. I mean, I don't know how the Supreme Court could cover that. And extortion is extortion. I mean, even though these law firms have agreed to pay it, the president still, in my opinion, conducted a criminal act in extorting those things. You can't operate unless you pay me off. Well, that's just extortion, pure and simple, because Donald Trump just should not have control over who gets in and out of the courts, because then he could just say, well, that conceivably he could assault somebody, and he could say, nope, you can't call me into court because I'm denying you access to the courts.
Right, and exactly, and as these law firms and judges are increasingly finding, it's violation of Fifth Amendment, obviously First Amendment, also Sixth Amendment right. You know, we haven't talked a lot about this in this broadcast, but your right to representation in our courts, right? You shut the courts down. You cannot have representation. It goes to a fundamental notion in our practice, Mark, as you're indicating here. Your larger issue is the one that needs to be shouted from the rooftops, right? Which is, what is the president doing here? He's got no capacity, no authority to do this, and yet he is signing these orders with wild abandon. This one, like the others, it's hard to rank them in terms of the level of outrage that they appropriately call for. This one, again, goes to our very system of justice, as we've talked about before, and you have articulated this before, Mark. Lawyers, for all of the appropriate ribbing that lawyers get, and yes, indeed, I enjoy lawyer jokes as well. This is no joke. This is no joke at all. We're attacking the lawyers because those are the ones who advocate on behalf of the interests of people, private interests. Yes, we don't always have to agree with those interests, but that's our adversarial system. You go into court, you try cases, you have hearings, TRO hearings, preliminary injunction hearings, and judges decide what the evidence is, who's reliable, who is credible, who is not, what does the evidence show? That's our system. You shut down the lawyers, you shut down the judges, which is also what we're heading toward, and you have basically, again, created what Sonia Sotomayor has bemoaned way back in July. You've created a supreme executive she fears for our democracy. Mark, appreciate that thoughtful comment as well in all of these areas. We also have Ali calling in. Ali, good to have you with me in our discussion once again.
My questions and comments go along with Mark's. I, too, was wondering about the legality of this whole law firm deal. I do, like Mark, I think that Trump extorted the money from them, and by offering this pro bono
right,
deal,
these services apparently at the election of the president, he decides apparently what the subject matter is. Whatever that money is, it's got to support those things. Again, even inside the extortion, Ali, as you're saying, is that the way we establish even understandings about how law firms should work? Go ahead, please. Appreciate the comment.
And when the law firms offer to do the pro bono work, they're giving him a payoff, which to me seems illegal for them to be bribing the President of the United States in that way. I just want to know, is there some way to hold both of them, all of them, accountable? The president, the law firms, for breaking the law. I know when a person two people do a job for each other in exchange, rather than money, they exchange a job.
Right.
That is taxable. Mm-hmm. That is considered money brought in. So basically, exchanging pro bono, that is money paid out.
Right. It has value. It has a thing of value, right? And Holly, your points are practical, but they're also legal. I mean, parties can contract to do certain things, but there are implications for that, right? And not only there are tax consequences when money changes hands. The issue that you're raising, the reason why you're scratching your head, and probably even more than that, as our other callers, other listeners, I suspect, is that this all just flies in the face of how we've understood America works, right? And thankfully, we do have judges out there. We've got 3 of them now, probably more as the president continues to issue these executive orders. Who knows who's next on the hit parade here of our president going after hits against other law firms. But we do have judges who are finding that, yes, indeed, and here is the remedy, that there are violations of the First Amendment. You cannot do this. Ensuring that these law firms do have access to the courts, that they are not prohibited from representing clients, and finding, and this is no small thing, and even if there's not money attached to it in terms of a civil damages, finding that the president's engaging in violations of the Constitution, the First Amendment, the Sixth Amendment, right to representation, free speech, all those kinds of things. That is no small thing. And again, Ali, people like you and other callers like Mark and Dale and Cindy need to be shouting that, as I say, from the rooftops and ensuring that we all understand that this is the President of the United States of America. Findings being made by judges on all sides of the political aisle. These are not one side or just another. Everybody looking at these kinds of things, expressing the same kind of outrage, Ali, that you have articulated here. I thank you so much for your comment and encourage you and others to call in down the road. As this issue, of course, is not over, as you're also suggesting, Ali. There will be more. And the need for all Americans to be upset about this attempt to undermine our rule of law systems. This is one component of a larger effort here. Not only troubling, but frankly destructive. And ultimately, as Sonia Sotomayor and Elena Kagan and Ketanji Brown Jackson said on July 1, this is the kind of open door to the ultimately the demise of a republic, because the basic institutions that rely on are no longer supported, and they're being destroyed by the President of the United States of America. Oh, my goodness. Thank you very much for that call, the other inquiries as well. We appreciate that, even as we move into more judges. And yes, indeed, a common theme here on our broadcast station, seconded by many of our callers, that it is the federal judges right now who are providing the principal guardrail to prevent this president from running roughshod over some of those. The significance, of course, is whether or not he's abiding by their directives, their injunctive orders, their TROs, their temporary restraining orders, telling him no. In some instances, apparently saying to him, we don't care, those judges. Saying to the judges, the president is, we don't care, we're going to do what we want. And one of those, of course, is that Venezuelan immigration case. What do we know? We know that James Boasberg, again, now having been assigned this Signal case, another case, random distribution there in the District of Columbia. He is the fellow who's also still wrestling with whether or not the law was properly invoked, the Alien Enemies Act, and even more significantly, getting stonewalled by Pam Bondi, by the government, by your administration. He wants answers to simple questions that happened 2 weeks ago when we were actually on the air here over the weekend broadcast, and James Boasberg saying, keep those planes on the ground until I can review this. Do not send them off to El Salvador. And the question to this day remains whether or not there was an overt violation of the judicial order if the administration, if those folks responsible for that deportation without due process said, we don't care, we're going to send those folks on anyway. He is still asking for that and has still not gotten any of that information. In response, now, the latest response by Pam Bondi has been, well, that's a state secrets, and for that reason, we cannot disclose that to you. It would compromise the national security. And all of this, of course, now pending before just this past week, the United States Court of Appeals for the District of Columbia taking up, the administration did, the decision by Judge Boasberg. And when we come back, we'll talk about what the Court of Appeals did just this past week to affirm Judge Boasberg. And then also, yes, indeed, the role that our United States Supreme Court will take in the days just ahead as Amicus, a law review, continues here in the broadcast stations of Civic Media. a part of our continuing initiative here on Amicus Law Review. Second in our now probably weekly installment, calling it Injunction Function, the function of federal judges issuing injunctive orders, temporary restraining orders against the president in many different areas. We highlighted 5 of them last week. We got 5 more of them this week. This is not the entire universe out there. There's a lot going on. Let's talk again about those Venezuelans. The Venezuelan supposed gang members, according to the administration, packed into 3 planes about 2 weeks ago. 200 of them now in a high-security prison in El Salvador, presumably outside of the jurisdiction of the federal government. At least that's what your administration is saying now. Just this past week, a federal appeals court, a 2-1 vote of the United States Court of Appeals for the District of Columbia, upholding what Judge Boasberg has been doing. Basically saying, yes, indeed, his efforts to try to stop this from happening, his efforts to enforce the basic due process rights of these folks, these 200, are appropriate. The Court of Appeals saying that the Venezuelan migrants are likely to succeed in their claims brought again by litigants in the district court, in the Court of Appeals in the District of Columbia, also that the government did not use its wartime powers. This Alien Enemies Act did not use that properly to summarily, without due process, transfer them to a prison in El Salvador without a hearing. And a footnote to all of this, of course, this is the civics portion, which we always affirm, important for everyone to know, regardless of how you feel about the Venezuelans themselves, the substance of what they did or did not do. We don't know anything about that yet because they weren't afforded due process. And the civics issue on all of this is you don't have to be a citizen in the United States of America to get the protections of this land that we all love, called the United States of America. The Constitution for 238 years has been provided to, and the rights established there for everyone who is here geographically. You don't have to be a citizen if you're a resident. Even if you're here illegally, we still treat you as human beings. That's what James Madison said. And if you're a supporter of our founding fathers, you have to embrace that fundamental notion. Regardless of what they did, which we don't know yet because they weren't afforded due process, they're entitled to just that. The Court of Appeals just this past week saying, yes, indeed, the administration almost certainly violated the Alien Enemies Act, not only in invoking it, this wartime power that they've invoked, saying that because these folks are alien enemies of our nation and that we are at war with them, that because of that, the law can be invoked. Not only saying that, but also raising questions, as Judge Boasberg continues to do, about the timing of all of this. So Judge Patricia Millett, one of 2 of the 3 judges who writes this, she says the government's removal scheme denies plaintiffs even a gossamer thread, the slightest, most ethereal thread, she says, of due process. And here's the important language that she finds based upon a review of what the lower court has done. She says, even though the government, yes, that's Pam Bondi, that's the U.S. Department of Justice, that's your United States government, acknowledges their right to judicial review of their removability. Not even a gossamer thread of due process packed on planes and sent off 2 weeks ago this weekend. That's Judge Patricia Millett writing in all this. Also, we've got Karen Henderson, one of the other judges. For what it's worth, she is an appointee of President George H.W. Bush. She's been on the bench for a long period of time. She's an excellent judge, and I'm saying that not because of her particular rulings, but because of the fact that she brings to all the work that she does, like all of the appellate court judges in that particular panel, all of them, a thoughtfulness and adherence to the facts and the law. What does she say? She says, this is Karen Henderson, sensitive subject matter. This is responding to Pam Bondi's latest position that we're not going to disclose any of this because it's all state secrets. It's all very sensitive. You can't have it, Judge, because it would compromise our national security. The judge says sensitive subject matter alone does not shroud a law firm from the judicial eye. Can't simply hide behind that, Judge Henderson says. Indeed, she writes, we have previously considered the precise sort of question, but the government contends we cannot. And likewise, joins Judge Patricia Millett in finding that what has happened here is unconstitutional. Likely, as we talked last week, that the plaintiffs here, the 200, or certainly a major portion of them, will succeed on the merits finding that the Alien Enemies Act was not properly invoked and that the rights to due process have not been given to them during the course of this. Now, what is the latest? What is the latest on all this, and why does it continue to be in our courts? Well, the answer comes just on Friday. Lots of things happen right before the weekends, as we know. Trump administration, Pam Bondi, the Office of the Solicitor General, who represents you before the United States Supreme Court on Friday, asked the Supreme Court to use a rarely invoked wartime law, which is this aliens law, the Alien Enemies Act, to deport these Venezuelans. Please, members of the Supreme Court, review what's going on at the lower court level. Judge Boasberg, this 3-judge panel of the Court of Appeals, emergency application. This is what is sometimes called, again, the shadow docket, but it's appropriate. Their emergency application. The Trump administration, as we know, is doing this with wild abandon, running quickly to the Supreme Court after the Federal Appeals Court right down the street kept in place that temporary block on deportations entered by Judge Boasberg. In an application to the Supreme Court, the Solicitor General argued the matter is too urgent. It's too extreme, too much requiring immediate action to wait for the case to wind its way through the district court, through the appellate court. Decide this right now. In the government's application, the acting Solicitor General, her name is Sarah Harris. We've talked about her before. She is your representative in front of the Supreme Court. She said the case presented, quote, fundamental questions about who decides how to conduct sensitive national security-related operations in this country. That's what she wrote in her application for emergency relief. She went on to say the Constitution supplies a clear answer. The president. She went on to say the Republic cannot afford a different choice. And so the justices set a speedy briefing schedule for the case. They're asking the lawyers for the immigrants file a response to this application by 10 a.m. on April 1. That's Tuesday. That's also, of course, voting day here in Wisconsin. 10 a.m. by April 1, the respondents to the plaintiffs in the lower court cases have to respond, not so much on the merits, although they will certainly address this, but whether or not the Supreme Court should take this up at all. Plainly, their view will be that no, this remain a matter for disposition for an evidentiary hearing to address the due process, to address the application of the law in the first instance. Do not steal this away from the lower courts. Supreme Court is going to determine whether or not they will grant certiorari on this. And again, this is important because the Alien Enemies Act, as we now have learned as a result of the administration's invocation of it, allows for summary deportations of people who come from countries, and here's the important language, at war with the United States of America. We are a nation in which we follow legislation passed by the Congress, right? That's what the Congress said. If you're at war with us, the Alien Enemies Act permits this deportation. The statute, again, best known recently, it's been invoked 3 different times, best known recently for the internment of Japanese American citizens during World War II. That's the Korematsu case coming out of the Supreme Court, roundly dismissed, roundly basically said bad law, grants the government broad latitude during a time of declared war or invasion to remove hostile nation people, alien enemies who are 14 years or older. Supreme Court now deciding whether it's going to decide those issues, taking them away from the lower courts as a result of what the Solicitor General has filed late this past week. When we come back, we'll talk about more injunction functions of the federal courts here on Amicus, a law review. Of civic media. Pursuing our newly initiated segment called Injunction Function, these times when federal district courts with great frequency, because of the great frequency of these executive orders, almost always, not uniformly, some judges are declining to enter injunctive relief, declining to enter the TROs. That also underscores the balance that they're bringing to all of this. Injunction Function already at much in evidence at the courts of the Court of Appeals, the District Court in District of Columbia, and now perhaps at the United States Supreme Court, maybe sometime in the near future, deciding whether or not it is going to review, among the 64 cases already on its docket, this matter involving the Venezuelan immigrants and their deportation without due process under the invocation of this law. That is the law that the administration says the people involved in this particular group called the Tren de Aragua, that's the gang that the administration has identified, should be subject to deportation under it because they're a hostile nation. They're subjects of a hostile nation because they're closely aligned, the Trump administration says, with the Venezuelan government and the leadership of the country's president, Nicolas Maduro. Trump administration also arguing that their arrival in the United States constituted an invasion under the act. The Supreme Court now taking that up. Needless to say, attorneys for the members of that group, the plaintiff group, the deportees, taking a strong exception to it, saying, among other things, that the conclusions that the government has come to about who these folks are, that their allegiance is to this hostile nation called Venezuela, part of this Tren de Aragua team and gang, in fact, premised upon tattoos that really resemble favorite soccer teams and not uniformly are tattoos of gangs. We'll see how this all plays out. Carolyn Leavitt, the White House press secretary, telling reporters the Trump administration would not reveal operation details. She called it a counterterrorism operation. Lawyers for the administration, again, telling a federal judge that it's not going to disclose any further information. We're not going to give you, Judge Boasberg, what you want about when those planes were in the air. And maintaining that doing so would somehow jeopardize state secrets. All of that presumably now on the desk, at least partially, at least preliminarily, before the United States Supreme Court. We talk about all of these injunctions, and again, it is a lot. There are a lot of them going on. We necessarily have some that end up on the cutting room floor, not because they're not important, but because we just simply do not have the bandwidth, right, to talk about all this. There are many of them. Let's talk about 4 more of them just this past week to give you some sense about what judges are doing as the guardrails of our nation to keep this president not at bay, not clipping his wings, as Carolyn Leavitt and others have said, not prohibiting the president from executing the law, executing it, the due care that he needs to provide that the laws are executed, but doing things that are beyond the scope of his capacity as established by the Constitution and indeed by legislation passed by the United States Congress. Federal judge in the United States District Court for the Northern District of Illinois, just across our southern border in Illinois, that's basically Chicago, has halted the Labor Department from requiring federal contractors or grant recipients of federal monies from certifying, which is what the president has said they've got to do, certifying that they do not operate any programs in violation of the Trump anti-DEI executive orders. Lots of things to unpack there. Basically, the president saying, if you are going to pursue any of those so-called DEI policies, we're going to prohibit you from engaging in any contracting, no grant recipients, and you've got to certify that you're not doing any of that DEI stuff. Judge Matthew Kennelly, Kennelly, U.S. District Court, Northern District of Illinois, just this past week, temporarily blocking the U.S. Department of Labor from implementing parts of President Donald Trump's executive orders aimed at doing what? Yes, indeed, curbing. Let's spell it all out. It's diversity, it's equity, and it's inclusion among federal contractors and grant recipients. This has been a core of our nation's understanding for years, almost ever since, at least in contemporary times, that we've been granting parties, private parties, contracts. If you're going to get the government's monies, your tax dollars, to provide services, to provide construction, other things in support of the mission of government, you have to do it in a way that complies with the law. And that means you've got to make certain that your workforce is not the basis of discriminatory hiring and firing policies and practices, that your workforce is treated fairly and without discrimination and bias as you do that. Our federal laws passed by the Congress command nothing less. And isn't it good that we have lived, at least up until this point, in a nation that has said that there is this string attached to federal contract dollars, and that is you can't discriminate against people based upon their immutable characteristics like race and national origin and familial status and sexual orientation and gender identity and, yes, religion and spiritual views and even economic status and all those kinds of things that go along with immutable characteristics. That's what our law has said. Judge Matthew Kennelly saying, yes, it still says that. You can't do that, Labor Department. Knock it off. Knock it off. That in response to a lawsuit that was filed last month by a group called the Chicago Women in Trades, nonprofit founded in 1981 that helps prepare women, again, for work in skilled construction trades, and indeed has several grants from the Department of Labor. A critical step now in ensuring that that organization can continue that important work that it does by virtue of what Judge Kennelly has done just this past week, likely an appeal. Where does this one go? It goes to our appeals court in the Seventh Circuit. Presumably, the administration already preparing its appeal of Judge Kennelly's order. What else is out there? Well, we talk a lot about deportation, right? That's Judge Boasberg. That's the U.S. Court of Appeals in the District of Columbia and arguably now the United States Supreme Court. President Trump's broad efforts, again, to deport migrants to places other than their country of origin hits yet another roadblock. This from the pen, the directive of another federal judge. He's in Boston. He's in the District of Massachusetts. His name is Brian Murphy. Brian Murphy, federal judge there. He issues a temporary restraining order. That is, once again, keep things in place until I can have a greater evidentiary hearing on this. I may issue a preliminary injunction. I might ultimately issue a permanent injunction. For right now, stop it, knock it off, don't do anything more. Temporary restraining order coming from the bench of Brian Murphy, Boston, requiring that the administration give migrants an opportunity to contest their removal on the grounds that they might be at risk of persecution or torture. Now, once again, this is a federal judge simply saying follow the law. That's what our law says. Brian Murphy ordered the government to give migrants, once again, a chance to contest their removal to a so-called third country under a federal law passed by the Congress, signed by the president, that limits deportations to places where the deportees, here's the language of the statute, the life or freedom would be threatened. He also, in support of his position, cited a United Nations treaty against torture. Trump administration has struck deals with Costa Rica and Panama, Guatemala, Mexico, El Salvador, as we know from the Venezuelan case, as a part of its effort to remove people who are difficult to deport to their home countries. Hundreds of migrants from countries in Africa and Asia, for instance, have been deported to Panama, a country whose migrants they have no tie to. Again, the judge, Brian Murphy, late this past week, once again telling the president, telling the administration cannot do that. There's more. Let's go back to the District of Maryland. This is Judge Julie Rubin, R-U-B-I-N, Tuesday of this past week, ordering the Education Department to restore some federal grants that were terminated as a part of Donald Trump's purge of DEI, the Diversity, Equity, and Inclusion programs. Again, these are all connected, are they not? She issues an opinion that says that the Department of Education has acted, here are her words, arbitrarily and illegally when it slashed, $600 million in grants that helped place teachers in underserved schools throughout our nation. The judge, Julie Rubin, federal district court judge, again appointed for life, confirmed by the Senate, appointed by the president. The judge also ordered that the administration cease future cuts of those grants. What do those grants do? The grants, again, inside the Department of Education, which, again, the president is attempting desperately to shut down, also without constitutional basis, also contrary to what the legislation has said. Those grants programs that Julie Rubin had in front of her provide training and certification of teachers to work where? In struggling districts that otherwise have trouble attracting talent. Those programs cited goals that include training a diverse educational workforce. Isn't that a good thing? And they provide training and special education among other areas. All of that is what the Department of Education, your Department of Education, authorized by the legislature, authorized with respect to these particular programs, does to ensure equity and fairness and decency and, yes, fundamentally education in places where it would not otherwise be provided. In this opinion, federal judge Julie Rubin found that the suspension of those programs aimed at training and supporting educators would have a grave effect on the public. Those are her words, not mine, coming out of the Federal District Court of Maryland. And finally, let's talk about the Voice of America. Again, one of many cases out there. The Voice of America, federal judge temporarily blocking, once again, Donald Trump's administration from dismantling. Yes, indeed, he wants to shut down now the government-funded news outlet. You know what this is. You've grown up thinking about this and probably hearing about it routinely and even hearing these broadcasts. The Voice of America, VOA, preventing the termination of more than 1,200 reporters and other employees put on paid leave early this month for now. This is a U.S. District Judge J. Paul Otken, O-E-T-K-E-N. He issues a temporary restraining order, again, late this past week, barring the U.S. Agency for Global Media, USAGM, U.S. Agency for Global Media, which oversees the Voice of America, from disbanding the International Broadcasting Network and its connected radio programs. Can't do that, President Trump. Stop it. And the judge goes on to say this. He issues a 22-page opinion supporting this, again, invoking the Constitution, invoking the legislation. He says, because defendants, and those defendants are your government, it's the administration, it's Donald Trump, it is the leadership of the USAGM, failed to provide adequate reasoning behind the sweeping changes to USAGM and seemingly failed to consider any reliance issues in effectively closing the agency. They likely violated a section, it's section 706(2)A, of something called the APA, the Administrative Procedures Act, which requires that these things happen, if at all, with process, with due process. It requires an opportunity for notice, for people to come in and comment. You've seen this in many other circumstances, where the government can act to establish rules, to take certain actions. The Administrative Procedures Act, the APA, is this statute passed by the Congress many years ago that requires that our agencies do it according to process. Plaintiffs have thus met their burden of establishing. Plaintiffs, again, the employees put on paid leave, 1,200 reporters, other employees put on leave. They have met their burden of establishing a likelihood of success on the merits. That's what Judge Otken said just this past week, again, indicating that he'll revisit this down the road when he schedules a hearing on the preliminary injunction. But boy, it sure looks to him as if they've established at least a likelihood of success on the merits based upon our education that we have done in the past, understanding once again that that's one of the standards that district courts and, yes, appeals courts look at when determining whether or not to enter into one of these injunctive orders. Oh, lots of things going on. Venezuela, DEI, slowing deportation plans, restoring grants to schools, dismantling the VOA, all of that being stopped by federal district court judges just this past week. We'll continue to talk about the injunction functions of our court. They're the guardrails right now. They're the folks you've got to be supportive of, and they will not respond plainly to your letters or your emails, but they should know that you have got the support regardless of what they decide. Regardless of what their ultimate decisions are, the process is everything. Due process is everything. The Administrative Procedures Act is everything. And they deserve our support in the midst of the attacks being forced upon them by the president and by other forces in our land. When we come back, we'll talk more about that. We'll talk about the Supreme Court. And also, again, taking your calls at 855-752-4842. All of that here on Amicus, a law review. This is Amicus, a law review, spending a lot of time necessarily in this edition of our broadcast talking about the attempts of our president to change the nation in which we live, issuing lots and lots of executive orders, finding not universal appeal for those orders at the federal district courts, just the opposite, finding an awful lot of judges who are not willing to go along with his invocation of the laws as he sees it, his invocation of the Constitution. None of these cases reaching final disposition, some of them, again, plainly heading to the Supreme Court, including that Venezuelan case. Other cases, the subject of further proceedings. That's what it's all about. We don't have final dispositions on all of these issues. It may well be that the president's got some authorities in these areas, but the judge is saying until we get to that point, let's have hearings, let's have due process, let's have evidence, let's have people come in and give me some sense of what these programs are all about. Let's talk about documents, let's talk about discussions and the reasons for stopping or not stopping these programs and the harms, the real focus of this, the harms if in fact those programs are suspended. We'll continue to monitor all of that. Many cases I suspect we're going to be chatting about in future editions as well. Appreciate, as always, callers coming into our broadcast. That includes you, Dick, from Madison, calling in. Appreciate your comment, your question, your inquiry this weekend.
First of all, James, thanks so much for your show. Even if it is scarier than I'll get up.
It is. Regrettably, that is the consequence of describing this, is it not, Dick?
And I don't feel crazy about asking this question anymore.
All right.
We're, 20 months out from the midterms, and they have such a slim majority, the Republicans. If they read the tea leaves, if they take a bath or lose the majority in the House and the Senate or one or the other, I think this guy is crazy enough that he'd declare martial law to stop the elections. And if that were to happen, what, if anything, can the courts do?
Right. And again, Dick, the fact that you and other callers are raising these things that, again, probably 4 months ago, again, even after the election, you never would have thought of, right? But so no reason to apologize because of these kinds of things. We know they happen on the face of the planet, right? We know, Dick, you know this well. I think you and I have even talked about this before. We know what happened in South Korea not that very long ago. We had another president there, again, in the midst of political turmoil, admittedly almost shut down political paralysis there. He decides to impose martial law because he doesn't like what's going on. He wants to be able to do what he wants to do. Some dramatic, although, again, distinguishable parallels between what's going on there and what's going on here. Imposes martial law. What does the nation do? And this gets to your question, Dick, about what can happen. Well, at least the South Koreans said, we're not going to tolerate it, right? And they took to the streets right away in Seoul and other places, and they ensured that their representatives could get into the National Assembly, quite literally boosting them up over the fences where the police were trying to keep them at bay. They get into the National Assembly. They vote to overturn what the president has done to stop martial law. That was on Tuesday in South Korea. They do that. They go on, and what do? They go on to impeach the president. They remove him from office, even while that's pending, all that going ahead. Further charges against that president and other people for doing just this. That's an aggressive public. That is an aggressive public. The question is, does America pursue that? If, in fact, Dick, the question you ask, unthinkable maybe, unthinkable in America, especially if it comes in the wake not of a true threat to our national security, but because of some political dismay in the office of the presidency, in the White House, in the Oval Office. What is the response of that? Well, certainly there are people who run into courts. The federal district courts we've talked a lot about today. There are certainly people who will go to the appeals courts, ultimately maybe to the Supreme Court, even if there are attempts to impose martial law. An awful lot of people asking about who would execute on that, meaning who actually implements martial law if indeed a president were to do that. It is unthinkable, right, in this nation that would happen. And yet we ask these questions because of the great number of things that this president is doing right now that are also unthinkable, stopping the basic rights of Americans and non-Americans, non-citizens from pursuing what we know are their rights. Among other things, first out of the gate here, trying to establish that people who are born in our nation, under the 14th Amendment, do not have citizenship. That's fundamental. If a president's going to do that kind of thing, what else is he going to do? Well, he's done many other things. We will certainly, Dick, if in fact that happens at some point, plainly the media and the citizenry of America will respond to that kind of thing, offering plainly the advocacy here on Civic Media is we need to be attentive to this right now. The protests underway, which are increasing in appropriate focus and numbers and geography across America, those need to continue to let people know that this is not our America, even as the things in court proceed apace. Dick, appreciate the call tremendously. We know as well the Supreme Court hard at work just this past week and hard at work also next week as well. Let me tell you a little bit about what's coming up, and then we'll just begin our analysis, which will continue again in our next show, about the oral arguments of just recent date. This coming week, a busy Supreme Court, 4 different cases coming up. One of them of huge significance coming out of, yes, indeed, the state of Wisconsin. Monday, March 31st, a major case involving a particular section of our civil statutes involving habeas petitions and whether a prisoner has exhausted appellate review before going and seeking habeas corpus relief. It's a big issue. Habeas petitions are important. The case is Rivers versus Guerrero. It's going to be argued at 10 a.m. Eastern Time this coming Monday. As always, you can listen in to those oral arguments for real in live time. You can also, by virtue of what our Supreme Court Chief Justice has permitted, you can also hear the arguments, including those of just this past week, on the docket of the Supreme Court. Here's the big one also coming up just this Monday. It's called Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission. The case concerns whether denying a religious organization an otherwise available tax exemption based on the state's, in this case Wisconsin's, criteria for religious behavior violates the First Amendment, and whether a court may require proof beyond a reasonable doubt in addressing challenges to the federal constitutionality. The question presented: does the state violate the First Amendment's religion clause by denying a religious organization an otherwise available tax exemption because the organization does not meet the state's criteria for religious behavior? Fascinating issue again under the Establishment Clause, tied up, of course, with the Free Exercise Clause. We know in recent times that the Supreme Court, at the pen of the Chief Justice, has moved from an entanglements analysis to determine whether or not there's prejudice against religion and spiritual groups. That case coming up for argument on Monday, along with 2 others on Tuesday and Wednesday. We're going to spend some time next time talking about the major cases that the Supreme Court entertained this past week involving, yes, indeed, voting rights and asylum rights and air quality and non-delegation doctrine under federal internet subsidies. All that coming up next week on Amicus, a Law Review. Stay with us. Engage in our discussion. Have a good weekend, everybody.
The national news cycle never stops, but it can be hard to find news about your local community. Civic Media is dedicated to providing quality local and state news coverage across Wisconsin. With the Civic Media app, you can get notifications about local stories that matter to you and your community. Find the free Civic Media app in your phone's app store and choose notifications from the menu to tell us what kind of news you want to hear about.